Court of Appeal Division 1 is now in session.
Good morning. Please be seated. This is the time and date set for oral argument in cause number CV240272. Center for Arizona Policy et al. Versus Arizona Secretary of State et al. And we have interveners Arizona Attorney General et al. So, these proceedings are being audio recorded as well as video recorded, so I ask you to please introduce yourself and your client at the beginning of your presentation. Each side will have 20 minutes in which to present your argument. Appellant's counsel, you're required to keep track of your own time if you want some for rebuttal. We have read the briefs. We have discussed this case in conference this morning. We are familiar with the facts underlying. Please keep that in mind during your presentation. At this point, and I wanted to say, Judge Gould, Mr. Gould, are you ready to proceed?
I am, Your Honor. Thank you. For what it's worth, it's just as awkward for me as it is for you. Your Honors, my name is Andrew Gould. I'm counsel for the appellant in this case, or the appellants, Center for Arizona Policy and the Arizona Free Enterprise Club, as well as John Doe's 1 and 2. When I sat down last night and looked at this case, I thought, my goodness, there is so much. The briefs are so long, there's so many issues, there's so many amici. What is the essence of the case? What are the primary claims that we have? And so I'm going to attempt to do that now, is to address what I think, on behalf of the appellants, the primary claims are, without prejudice to all of the claims that have been raised in these briefs. And I would outline those as 4 issues. One is overbreadth. The other is the statutory scheme fails exacting scrutiny. Third, there is a as-applied challenge that is meritorious in this case. And fourth, there is at least one provision that suffers from vagueness. In terms of overbreadth, the framework here categorically sweeps in all donors, whether or not they support campaign media spending. And I think one of the things that's been overlooked in the briefing is the original source or traceable donors. So under the statute, if I am giving $5,000 or more, I also have to report anyone who gave me $2,500 or more. So I report that, and then it's all disclosed. So a couple things about that original donor. They're never given an opportunity to opt out. If I'm a $2,500 donor and I'm bundled in with a $5,000 or more donor, I'm never given the opportunity to opt out. I'm never given the option to think about what the campaign media spending may be or how the money may be used.
But couldn't the $5,000 person advise the other person and find out if they want to opt out? They are given, someone is given an opt-out notice, and if they want to continue receiving funds, why wouldn't they advise people who've given them money?
They can, Your Honor, but the point of this statutory scheme, the interest that is promoted is education of voters. It's an informational interest. So think of this scenario and how this is supposed to help a voter. Someone gives $2,500 to another donor who gives $5,000. The $5,000 donor says, I want to opt out, but they don't really know what the money's going to be spent for. The $2,500 donor can be told that they can be opt out, and so the original donor, let's call him Jim Smith, gives to Andy Gould, and then Andy Gould gives that money to the Center for Arizona Policy. And all of that is disclosed to the voter. How does that help the voter know who's supporting whatever that campaign media advertising is, to know that...
How does that help your overbreadth argument? I mean, it seems to me that you're making a policy argument where the limit should be higher, but that doesn't necessarily go to an overbreadth argument.
I believe it does, Your Honor, because
well, explain it to me then.
It sweeps in donors and makes donors be disclosed that have no bearing whatsoever to the purpose of the act because it's not informing voters. So it's a categorically overbroad sweep of donors. At the same time, the courts have said that there is always a chilling effect on free speech. So you're chilling the speech of these remote donors that bear no relation whatsoever to what a voter would want to know
But
about
if
the
the remote
organization.
donor gives directly to a candidate, that's disclosed, right?
Well, that's totally different, Your Honor.
Isn't that kind of the point of doing this? And under our state constitution, we want to know who's giving money so we can figure out if there's some quid pro quo or whatever the rationale for knowing who's supporting or knowing what legislators subsequently do. But if it's disclosable, if it's a direct contribution, doesn't that same logic apply if we've just set up sort of a middleman to pass the contributions through?
Well, the U.S. Supreme Court doesn't agree with you, Your Honor. The U.S. Supreme Court in Citizens United says that this quid pro quo idea doesn't apply to IEs because there's an attenuation and there's the no coordination rule. And so Citizens United has expressly stated that this idea of anti-corruption or quid pro quo or bribery doesn't apply to IEs.
Even assuming it's not quid pro quo or bribery, I mean, don't we want to know if there's a campaign ad that says police officers support this candidate, and it turns out the contributions were from some industry that's entirely unrelated to the police. I mean, don't we want to know who it is who's actually paying for an ad that says something?
Well, we also want to protect speech. We want people to be able to contribute to charitable organizations that they support without having that speech chilled. And whenever you disclose somebody's name and you publish their employment, their address, their name, then you are going to chill their speech. So the question is there a substantial relationship between the reason why you want to disclose somebody's name and the speech that is chilled? And so there has to be a balance there. I suppose, Your Honor, it would benefit people to know who everybody voted for. But we don't do that. We don't make people say, or we don't publish who people voted for because we want to protect their speech.
We do require direct contributions to be disclosed. So that's not a violation of free speech. To just the disclosure. I'm still a little bit puzzled by how just having an intermediate step chills free speech if it doesn't chill speech to require a direct contribution.
Your Honor, I want to try to understand your question. Are you questioning the scheme that's been set up by the Supreme Court that allows for contributions to be made
I'm
to
just saying
independent
under our state
expenditures?
constitution that requires disclosure for direct contributions to a candidate. You agree does that chill free speech?
It does chill free speech, but we have weighed the interest of the quid pro quo because it's a direct contribution to an individual. We cap those limits, and the U.S. Supreme Court has repeatedly said from Buckley all the way through Citizens United that we can do that. The Supreme Court has also said that the quid pro quo...
Capping, I can see where capping would be a restriction on free speech, but we're just saying it's not a restriction to require you to disclose. But if we just send it through a middleman, it's now chilling free speech in a way that it doesn't chill if it's a direct contribution.
Well, Your Honor, the courts have clearly said disclosing people's names who donate to charitable organizations does chill free speech. There's no question about that. So the question is, what's the reason for doing that, and does that reason outweigh it? So I guess my response to your question, I hope I'm answering your question, Your Honor, is transparency isn't the only value here. Speech is an important value, and when you take somebody's name and you force them to disclose that and publish that, you have definitely chilled people's speech. People will oftentimes not give. But the court has said if there's an important interest that kind of weighs that, then we balance that and we'll have disclosure.
And we have a case law that says informational interest is enough. We don't even have to get to corruption, do we?
No, I agree, Your Honor. Corruption isn't an interest here with these types of contributions to IEs. But you have to have an informational interest. And what I'm saying is, in Bonta, the Supreme Court tightened up that prong of the fit of the tailoring and also the substantial relation and said this is a robust prong of the test. This exacting scrutiny, they use language in Bonta that comes almost all the way to strict scrutiny. It's not. I recognize
Are you
it.
abandoning, just to make sure that I understand, are you abandoning your original argument that we should apply strict scrutiny?
No.
You're not. You're still
No.
asking us to do so.
I am. I think that this is a content-based restriction, and content-based restrictions trigger strict scrutiny. But I am arguing, Your Honor, that this is overbroad. It's also,
And this doesn't keep people from donating confidentially to an organization. So it doesn't mean you can't support whatever charitable or organization that you believe in. It's just that if they're going to use funds to spend on a media campaign, and then you're advised that. So why would it be chilling and preventing people from supporting organizations? They can support the organization, and it's simply a restriction on support that leads to a media campaign.
Your Honor, you don't think that it chills free speech to have your name published and your address and your employment on what organizations you give to? Do you actually think, Your Honor, that giving to CAP and having your name published as giving to CAP doesn't impose some type of speech restriction on you, that there aren't repercussions for that? I think we live in a different world.
But if you opt out, what are the repercussions? If you opt out, I'm giving you money, but I don't want it to be spent on a media campaign. There are other valuable things that organizations do other than a media campaign. So is it still, what's the problem with that approach?
Your Honor, if I may, because I think it's backwards. And I'm not trying to offend you. I think it's backwards. We start with the protection for free speech. We only take away or we chill free speech if there is an important government interest to deny that. So again, the case law is uniform, that when you disclose and you publish organizations that people have contributed to, it is a burden on your free speech. That's why people give anonymously. That's why they give to charities. That's the starting point. And so that then to force that, to compel that disclosure, there has to be an important government interest. So I think the starting point is different, at least from my perspective, Your Honor, than yours.
So we get back to there's a compelling government interest to inform the electorate. And why is that not enough in this context? You're arguing over breadth that it's too far attenuated because it says original source and the $2,500 to the $5,000. But isn't information the government interest that gets this across the finish line?
Well, it has to be a substantial relationship. It can't just be any relationship. Think of it this way, Your Honor. What would be the informational interest in just simply disclosing every single donor of every charitable organization? I think we could all agree, well, what do the voters learn about that? So as we get more and more attenuated...
Every organizational interest is not engaged in political speech. Every charitable organization is not. So we're talking about organizations that engage in campaign media spending. That is much different than every charitable organization.
And their names are disclosed. That organization is disclosed. What this statutory framework does is reach down into the individual donors. And so the question is, what benefit does the voter get in terms of informationally from learning the names of these donors? And the sweep is too broad to reach all the way down to someone who might give $2,500, could be advised by a $5,000 donor, but their name still gets disclosed. What do you learn that Andy Gould gave to Scott Freeman, and Scott Freeman then gave to CAP? What does the voter learn from that? If it's not, now what the voter can learn is, if it's earmarked, if the donor says, I want this money spent for this campaign media spending, I want this money spent for this, then the individual voter can look at it and say, here are the donors that contributed to this organization that supported this media campaign, and they know who's behind it. But what do you know about who's behind it if it's just a person who's giving to the organization. You're not learning anything about who's supporting it because it's so remote and attenuated. It's not supporting the campaign message. That's the problem. And narrow tailoring, in addition to overbreadth, requires that you make this fit tight. And it's not narrowly tailored because it's pulling in and sweeping in as a categorical matter all types of donors who may or may not really support anything that's in that campaign media advertisement. And simply because they're given an opportunity to opt out doesn't mean they support it. So again, getting back to...
I'm not following that. I understand that opting in would be a different way to approach it, and that would make sense, certainly, to say, I've affirmatively opted in, I know my money's going to be spent on a media campaign. That would be more narrow. But I'm still puzzled by giving you the chance to opt out. Isn't that sort of the same thing? You're told you can opt out, and if I don't want to, aren't I essentially opting in if I don't?
Does that mean you support it? I mean, you didn't opt out.
You're told by the organization that you have a chance to opt out. Otherwise, we're going to spend money for a media campaign. Is it that much different than an opt-in provision?
Well, if you're trying to inform voters about who supports campaign media advertising, I don't think that's a substantial relationship or narrowly tailored. Those are the tests. It's not just, does it loosely fit and in some minimal way give you some information. It has to be a substantial relationship and it has to be a tight fit. That's what the Supreme Court has said. And I would argue that's
It has to be
tight.
the most narrowly tailored
No.
under this standard.
No, but it has to be a tight fit. What is a tight fit? What does narrowly tailored mean? I don't think that this supplies that. If I may, I know I'm running out of time here. The 20 minutes always goes so fast, probably from your side as well. I think also there is a serious issue here with the description of what constitutes retaliation and the protections under the statute. It limits it to serious physical injury only. That's never been the Supreme Court's test for retaliation. Not only does that suffer from overbreadth, it also puts too high of a standard for the as-applied challenge. What that statutory section literally says is you can spit on somebody, you can burn their house down, you can destroy their business, you can ruin their reputation, you can destroy their marriage, you can even physically attack them. As long as it doesn't rise to the level of serious physical injury, there's no protection for you. That's never been the standard. That is not narrowly tailored to protect the chilling effect of retaliation. That is overbroad, and for the as-applied challenge, we've given a number of examples that fit within that. I also wanted to touch on one other issue here, and that's the vagueness of it's subsection 972A, I think it's subsection 7I, and that's the language that talks about any actions or activity in conjunction with or in combination with. That also makes it overbroad because that reaches activities that are so attenuated from any type of campaign spending, it literally could sweep in anything. I would give you an example. If there's a law prohibiting running a red light, if it's in conjunction with or in combination with, literally is putting gas in the car, in combination with or in conjunction with is starting the car. And so here again, you go to overbreadth because it's sweeping in activity that extends way beyond anything that could be in conjunction with or in combination with electioneering or political advertising. And it also doesn't give proper notice about what constitutes campaign media spending. With that, I'm going to reserve...
When you say
I knew you were going to take the rest of my time, Judge Catani, but go ahead.
You argue that you could suffer diminished social standing. How could that be a standard that could ever be applied? You're saying some people might think less of you if they know that you've contributed to something. That's enough to say that...
Social ostracism?
Diminished social standing does not get to ostracism.
Diminished social standing, I believe, is the term you used.
Well, maybe I misspoke. Maybe diminished social standing isn't the proper term, but reputational harm is. I I represent a number of professors at UCLA who are subject to anti-Semitism. Think of it this way. Those professors, many of them support pro-Zionist causes. They've had to walk through encampments over there at UCLA of angry students that are pro-Palestinian. What would happen to those professors if they contributed to a pro-Zionist C3 or C4, and that was used for campaign media spending on a certain issue, and that was reported and disclosed to those students? Would they continue to go to their class? Would they be able to walk into the building? So I think part of what I would ask this court to consider is this is a different time. This is an acrimonious time. People giving to any cause, and you can look on the right or the left, their businesses are destroyed, there's an ability to put their names on the internet and dox them. We have to be able to protect contributions to charitable organizations. This reaches too far. It reaches too many donors. It doesn't protect for a wide variety of retaliation. The only retaliation it protects is for serious physical injury. I can't find that standard anywhere, in any case, in any other statute. It is the most extreme, chilling provision I've seen in any campaign disclosure law. Thank you.
Thank you. Counsel, when you're ready.
May it please the court, I'm David Kolker, representing Voters' Right to Know. The defendants intend to split their time. I will take about 15 minutes, and Eric Frazier, on behalf of the state government defendants, will have the remaining 5 minutes.
Thank you.
Although Prop 211's requirement to disclose the original source of campaign funds is relatively unique, the constitutional issues it raises are not. What's unique about this statute is that it does trace back, but it is actually more narrowly tailored than most other disclosure laws because of the notice and opt-out opportunity that it has embedded within it. Its purpose, in effect, is simply to restore campaign finance disclosure laws to what they were always meant to be, to disclose the real money behind these election ads. And because of the explosion in so-called dark money that we've seen in recent years, we now have front groups being listed in disclosure reports when all that's listed is the last donor to the spender. Rather than infringing on First Amendment rights or the free speech rights embedded in the Arizona Constitution, Prop 211 actually promotes the interest served by these constitutional provisions by bringing critical information to voters so that they're educated when they participate in self-government.
What do you make of Mr. Gold's argument regarding the attenuation between the original source of money, $2,500, that person didn't get to opt out?
A few things, Your Honor. First of all, nobody who gives on only $2,500 gets reported to the public. That information goes to the covered person who does the reporting, but you only get reported if you gave $5,000 or more. So the beauty of this statute is that when a covered person intends to do campaign media spending, that spender has to notify its donors that it may use that money in that way, and they're given an opportunity to opt out. And as Judge Catani was discussing earlier, nothing in this law stops the direct donor from talking to the people who gave him money. And the idea that somebody would pass on money to a donor that then is given to the spender, and the donor has been told, your names are going to appear if you don't opt out and if you give more than $5,000. And the idea that, say, I as the donor who's giving the information to the spender would have gotten a big chunk of money from somebody, and I'm not going to talk to that person to say, you know, you gave me $10,000, I'm going to pass it on, they're going to use it for campaign media spending. Are you okay with that? And there's a lot of flexibility built into the statute, because when the donor gives, say, $10,000 to a spender, the donor only has to give the original source information of the money that's being passed on. So if I have $100,000 in my possession that I got from other people, and I give $10,000 to a covered person, I only have to I can tag the $10,000 that I'm giving to the spender to have come from whatever original source I choose, because you only have to reveal the upstream donors to the extent that money's being transferred on to the spender. So there's a lot of flexibility built into this for the donors, and people can talk to each other, and the law assumes that people will learn how the law works and they'll take advantage of it. And nothing in this law stops the original source from saying, well, I'm going to give you money, but don't give it to anybody who's going to spend it on campaign media spending. 501c3 organizations, for example, restrict funds all the time when they give it away, because the money that they have that they give out at grants can't be used for political purposes. This is not an unknown thing where you give away money but with certain restrictions. And nothing in Prop 211 would stop anybody from doing that. One of the things that Mr. Gould brought up was Citizens United, but he mischaracterized it. Citizens United spoke about two things. It struck down the limit on corporate spending. It used strict scrutiny for that because it was a direct restraint on speech. But then it upheld, by a vote of 8-1, the required disclosure for those very corporate communications. And they didn't have to expressly advocate. One of the ads that had to be disclosed was a 10-second ad inviting people to see a movie about Hillary Clinton. But because it was talking about a candidate shortly before the election, the court said that the public has an interest in knowing who's talking about candidates. And really the Supreme Court started back with Buckley. And the court identified three important interests in having this information. The first is to educate voters, because one side of the First Amendment is what Mr. Gould talked about, the potential chill, which the court recognized. The court said, we understand that some people might not want to be disclosed, and that is a chilling effect, but it's outweighed by other First Amendment interests, because the reason we have free speech is to have robust debate, the marketplace of ideas, an informed electorate to participate in self-government. And the other part...
What's your response to Mr. Gould's argument that we have a carve-out if there's a danger of physical harm? And I assume everybody agrees that a danger of physical harm is probably a good carve-out, but if that's the only carve-out, is that enough to protect people?
Your Honor, most campaign finance disclosure laws don't have a statutory carve-out for an as-applied challenge. We're not contesting that the court should apply the as-applied standard in terms of reasonable probability of harassment or retaliation. We're not trying to, when we have argued against their as-applied challenge, we have not relied on the statutory provision. We understand that there's a constitutional right to as-applied challenges that is broader than the statutory one. But the second, I just want to finish with Buckley, the second informational interest is a form of corruption prevention. Under the law, if you give money directly to a candidate, that's quid pro quo corruption, and that's why we're allowed to have limits on campaign contributions. But there's an informational interest in preventing corruption as well, because when people know who the big money is behind even independent ads supporting a candidate, the courts have held, Buckley up to Citizens United, that this is a way of allowing the people to have this information to hold their office holders accountable. So if they know that somebody spent $500,000 helping to get them elected, even if that effort was supposedly done independently, people can look and see, well, are special favors being done for that kind of spending that supported the candidate becoming an office holder? I think it's important to understand the structure of appellants' arguments. On the one hand, they're incredibly broad, and they're really attacking all campaign finance disclosure laws. But there's simply no right to have an anonymous campaign contributions. In more typical disclosure regimes, the names are reported of people who give to the person who has to report, whether it's a candidate, a political party, a PAC, or an independent spender who has to make disclosures. But when people give money to the Sierra Club or the NRA or even to a candidate or a political party, They don't know exactly what the ads are going to say. The law has upheld these disclosure laws without requiring that the check written means that they bless everything that a charity or even a candidate does. People may support 80% of what a candidate believes in. That doesn't mean they're going to want to bless every ad that candidate puts out. And the law has never required that kind of connection. So there's no reason to expect to see that here as well. And in fact, the opt-out provisions make it easier for people to support a charity. I want to give to the NRA. I love their firearms training, but I really don't want them spending my money on candidates. Or you could say, make up the same example about the Sierra Club. So the beauty of this law is it allows people to continue to support charities, but just say, take my $10,000, but don't spend it on campaign stuff, and don't report me. And that's what this law allows. In terms of overbreadth, appellants basically ignore the plainly legitimate sweep of the statute. And to prevail in a facial challenge, which is what the guts of this case is about, they have to show that there's a substantial number of unconstitutional applications despite the Act's plainly legitimate sweep. And they basically ignore its legitimate sweep. This Act has, and it has a legitimate sweep in part because of how narrowly tailored it is. Not only does it have the opt-out feature that we've talked about, but it has very high thresholds. You don't get reported unless you give $5,000. That's 5 times the federal limit. And other places report you if you give $100. Covered persons have flexibility too. They have to do the reporting, but they can choose when they give the notice and to whom they give it. So if covered persons want to spend money on an issue, but they think that some of their donors are not going to be happy with that, they don't have to give the notice to everybody. They can pick and choose which donors they'll hit up or try to hit up for a campaign donation. Administratively, covered persons don't have to set up a separate organization, like a separate PAC, that a corporation would have to do under federal law. They don't even have to set up a separate bank account. They just have to have records, transfer records of who has given money and who has opted out and who has not. And finally, the definition of campaign media spending is narrowly tailored. It has 7 subparts. They really only complain about one of them, and that's when you have a subsidiary expense. But they mischaracterize it. The purpose of this is just that if you spend $50,000 running a TV ad, but before you did that, you spent $10,000 on a videographer to create the ad, well, those underlying costs should be included. That's the kind of thing that is meant.
Data analytics that includes more than just, this is a commercial. So, I mean, it gets to organization for media spending, et cetera, and the in conjunction with or in preparation for language kind of muddies that water, doesn't it?
It's not the most specific language, Your Honor. The Commission has adopted a regulation saying that the underlying activity has to be conducted specifically for that. So
And
the example...
while I think we appreciate what the Commission has done, that doesn't help us in our analysis of the statute, does it?
Well, I think it does, Your Honor. I think what the Commission helped to clarify is that if you take a poll, for example, to find out what's most salient in voters' minds, and you use it for 5 different things, but it also helps shape a TV commercial that you create. I would say, under the statute and under the Commission's regulation, that that wasn't done in conjunction with that ad. It was done for several purposes, so you wouldn't have to include the polling costs when you're reporting the money that you spent for the actual disseminated TV ad.
So there was also the example, I'm going to run an advertisement to hire somebody to engage in media production. Is that in conjunction
No,
with?
I really think that's absurd, Your Honor. First of all, there has to be a public communication that exists before you would report the underlying expenses. So if you're advertising to hire somebody for general purposes, the way the statute is worded, subpart 7 applies to these subsidiary expenses for one of the public communications. Well, you have to have a public communication before you can have subsidiary expenses for it. So, for example, if I hire a
Does the public communication happen after the fact?
but you wouldn't report it unless it happens. So, for example, if I spend $10,000 on my videographer, but I never run the ad, you don't have to report that expense because it wasn't in conjunction with a public communication. I intended to do a public communication, but there was never actually a public communication that was reportable. So so you can't have underlying expenses for something that never came to fruition.
But you have, and I assume you also have to notify the donors that this is now an expense. Even this preliminary expense is going to be used now for a media campaign. So is it okay if we use your money for that? But you've already spent the money on that.
Well, the donor notification isn't specific that way. The donors have to be notified that their money may be used for campaign media spending. The spender doesn't have to tell the donor exactly how it will be spent. It just has to warn them that it will be spent, that it may be spent on covered activities.
Are there any repercussions for the donor if the organization gets it wrong in determining what is an expense that's going towards a media campaign?
No, there's no trace back in that sense, Your Honor. The point of the donor notice and opt-out is to let them know generally that it's going to be spent on, media buys and not some other, say, educational or lobbying purpose. And to warn them that if they don't opt out, their name will be reported. So that's going to happen. So if the donor doesn't opt out and they give enough money, they will be reported, assuming that the spender has crossed the $50,000 spending threshold and has to report its donors. But that makes sense because this person gave with permission to spend it on campaign media spending. The specifics of what it was spent on, no disclosure law tries to tie together that specifically the money that comes in and the money that comes out, even when we give directly to candidates or political parties. Your Honor, if I may, I'd like to turn it over to Mr. Frazier for the balance of our time.
Thank you, counsel.
Good morning, Your Honors. May it please the Court, my name is Eric Frazier on behalf of the state appellees. The plaintiff's argument that we heard today is that the public doesn't learn anything from who the upstream donor is, but what's being disclosed is where the money came from, whose money is being used. So if you have an initiative like an animal welfare initiative on the ballot, the voters in Arizona have told us by a huge majority that they want to know, is the money coming from animal rights advocates or is it coming from the pork producers of America? And that's true. They learn that money even if it's being obscured under the pre-existing law by funneling it through intermediaries with names like Save Our Furry Friends. What the voters told us is that they want to know where the money is really coming from. So the plaintiff's argument was squarely rejected by the Ninth Circuit in the No on E case, which is at 85 F 4th 493. In particular, page 506. The court said, here's the plaintiff's position in that case on page 506 of No on E. They take the position that the secondary contributor requirement could cause confusion because a committee must list donors who may not have had any position on the issue that the ad is addressing, or who may not have known that their donation would be used to promote those views. And that's the same argument here. In rejecting it, the Ninth Circuit said that adopting plaintiff's position could call into question the logic underlying decisions that uphold disclosure and disclaimer requirements generally, which is, I think, what the court was discussing with Mr. Gould. Then it says those cases emphasize that the laws at issue further the governmental interest in revealing the source of campaign funding, not in ensuring that every donor agrees with every aspect of the message. So the plaintiffs here are focusing on, did the donor know? Did the donor agree with the message? What the constitutional requirement is really about is, what is the government interest? And is this sufficiently related and narrowly tailored and so on? And the Ninth Circuit said that the interest is in revealing the source of the money, not in ensuring that every single donor agrees with that message.
Mr. Frazier, I'm going to ask you to address, because we're really limiting our time here, address the separation of powers argument that they're making.
Sure. So the separation of powers argument, there's no standing here because they need to show particularized harm. They need a distinct and palpable injury. Their allegations here are generic. They're essentially saying that they're literally saying unchecked enforcement actions that will come out of the commission. That is not particularized to them. Now, because the commission hasn't exercised any of these allegedly unconstitutional powers. And so if the commission exercised their powers in an unconstitutional way, and that affected the plaintiffs, they may be able to bring a lawsuit then. But right now, they are no different than anyone else who engages in campaign media spending. They don't have a distinct and palpable injury because of the theoretical possibility in a statute that supposedly takes away the legislative powers.
But you don't have to suffer an actual harm to bring the claim. I mean, yes, they have to show particularized harm, but that can be speculative at this point, can it not?
Well, I don't think there's, whether it can be speculative or not, there's no particularized harm from these specific separation of powers problems. They're saying, for example, that the statute takes away the legislative power. How are they harmed by that? Or they're not saying it takes away the legislative power. They're saying it may give the commission the power to exercise legislative powers. How has that harmed them when the commission hasn't done that, and there's no allegation that the commission has done that? They're saying that maybe someday the commission will exercise legislative powers, and that would be a separation of powers problem. But that hasn't happened, and so there's no harm to them. Really quickly, unless you have other questions for me, I want to emphasize that the overbreadth challenge here is a facial challenge. And so the question is whether a substantial number of the statute's applications are unconstitutional, judged in relation to the plainly legitimate sweep. So even if there is someone who donates $5,000 and that is passed along through intermediaries and they don't know it's being used for campaign media spending, that doesn't mean the statute is unconstitutional, even if that person exists. Because most people don't pass around other people's money. Thank you, Your Honors. We ask that you affirm.
And Mr. Gould, you have 1 second.
Thank you, Your Honor. I will pass my 1 second to...
Thank you. Counsel, rousing arguments. Thank you for your arguments here today, your briefing on this matter. We have enjoyed the constitutional issues and the exercise in getting to the bottom of this. So we will take this matter under advisement. We will issue a ruling in due course. Today is voting day. Everybody vote. We are at recess.